Donald Trump's legal team says they will appeal a decision to bar him from Colorado's primary ballot to the Supreme Court. The state Supreme Court has ruled that Trump violated the U.S. Constitution by inciting the mob to attack the Capitol on January 6th. So for more on this, we're joined by CBS News legal contributor Rebecca Roiphe. All right, Rebecca, how likely is it that the Supreme Court will actually take up this case?
It's extremely likely. While the Supreme Court has no obligation to hear any case, in this particular context where the legal landscape is so uncertain and the question is so pressing, it would be unthinkable for the Supreme Court not to act.
So, Rebecca, help me understand and our audience understand. On one hand, I'm wondering if this is a way to fast track the Supreme Court's rulings on whether former President Donald Trump was responsible for inciting an insurrection. And if the Supreme Court were to rule on that, that would have implications for the general election, I'm guessing. Or is it just to rule as to whether or not the Colorado Supreme Court has the authority to do what they've done? And if they say that they do not, does that mean that the other states are SOL, basically?
Right. I mean, this is the million-dollar question. I think it's extremely unlikely that the Supreme Court says that, decides in this particular case that the former president engaged in an insurrection. But that is one of the questions before it. I think it's far more likely that the Supreme Court chooses one of many off-ramps that would allow it to dispose of this case without deciding those crucial questions.
I got to tell you, when I heard this, I thought to myself, if I was arguing on behalf of the former president, I would say, what does putting a name on a ballot in a primary have to do with the ultimate thing you're accusing me of, right? Just because his name is on the ballot doesn't mean he's going to become the president. It just means his name is on the ballot.
And plus, he hasn't been convicted of anything.
Well, that's it. That's another part.
Right.
But I'm saying that we're not even close to that question yet. You're taking his name off a ballot. You haven't argued that that's unconstitutional. So I bounce the ball to you. What sort of argument could we hear from Donald Trump's attorneys?
Yeah, I mean, so the Colorado Supreme Court addressed that exact question and said, well, we decide all the time these sorts of questions. I mean, if a 25-year-old foreign national decided that they wanted to run for president, we would say, Secretary of State, you can't put that on the ballot. So this is similar. But the former president has a series of arguments. One is, of course, January 6th was not an insurrection. Two is that he didn't engage in that insurrection. Three is that this clause of the 14th Amendment of the Constitution does not apply to the presidency, but only to the named offices like Congress and the judiciary. And that finally, that Section 3 is not self-executing, that in other words, the state doesn't have any power to implement its provisions unless and until the United States Congress enacts what's called implementing legislation to put it into effect.
All right, Rebecca Roiphe, always great to have your legal analysis. Thank you so much.